Landon Gray Robinson filed a civil rights complaint on August 10, 2026, and it highlights a systemic breakdown in how the Social Security Administration manages disability benefits. This isn't just about a single missed payment. The complaint, officially in SSA 437BK, alleges that the agency used a person's very disability as a tool to obstruct the benefits they were already legally entitled to receive. We're looking at a case where a federal court stepped in, made a binding judgment, and yet 5 years later, the person at the center of it is still fighting for what was promised.
The details are quite startling because they point to a level of administrative inertia that has real-world consequences. Landon Robinson's case effectively began years ago, but the turning point mentioned in the complaint is a March 2021 judgment from the U.S. District Court for the District of Hawaii. In Robinson v. Saul, Judge Alan Kay reversed the SSA's denial of benefits and sent the case back. Under federal law, specifically the mandate rule and the law of the case doctrine, the SSA was legally bound to follow that court's direction. However, the complaint alleges that for over 4 years, the agency simply didn't implement it.
It's rare to see a complaint explicitly state that an agency is ignoring a federal judge. Usually, once a court reverses a denial, there's a set process. But Robinson is claiming that instead of paying out the benefits, the SSA actually made things more complicated by using his compliance against him. He says they told him to file new applications to get paid on the old ones, but then used those new filings to re-examine his medical status all over again. It sounds like a circular logic trap where the only way to get your money is to risk losing your status.
That is exactly the coercive cycle the complaint describes. One of the heavy legal hitters here is collateral estoppel. In Social Security law, specifically 20 CFR section 404.950F, if a fact or an issue, like whether you have a specific disability, has already been decided in a final way, the agency isn't allowed to keep relitigating it. If a court or a previous final decision said Landon was disabled due to specific impairments, the SSA is precluded from coming back a year later and saying, let's look at those same impairments from scratch. The complaint alleges a May 2026 decision did exactly that, ignoring the previous findings.
And there's this technical term used in the document, closed period. To someone not steeped in SSA regulations, that might sound like a minor clerical category, but for a claimant, it's a massive distinction. Can you explain why Robinson is alleging that converting his benefits to a closed period was a violation of his rights?
A closed period of disability is essentially a win with an expiration date. It means the SSA agrees you were disabled from point A to point B, but then they claim you improved and are no longer disabled after that. Landon had what's called Disabled Adult Child, or DAC benefits. Under Title II, these benefits are event-limited, not time-limited. They're supposed to continue until a specific event happens, like the beneficiary getting married to someone who isn't also a beneficiary or passing away. Robinson's complaint says the SSA essentially cut off his ongoing benefits by calling them a closed period without ever actually proving he'd medically improved. There was no cessation determination, which is a specific legal requirement under 20 CFR sections 404.987 through 404.989.
So they basically just stopped the clock without following the rules for stopping the clock. But the complaint also mentions he was working. Usually the SSA is very strict about working while on disability. They have the substantial gainful activity or SGA limits. If you earn too much, you're not disabled in their eyes. Doesn't that give them a reason to stop the benefits?
That's where the trial work period, or TWP, comes in, and it's a major part of the legal claim here. Under 20 CFR section 404.1592, beneficiaries get 9 months where they can test their ability to work without losing their benefits. The law is very clear. Activity during those 9 months cannot be used as evidence that your disability has ended. Landon's complaint alleges that the SSA took his work history during that protected window and used it as the justification to deny him. It's a direct violation of the safety net the government itself built to encourage people to try returning to the workforce.
It feels like a damned if you do, damned if you don't scenario. If he doesn't work, he can't survive while waiting years for the SSA to follow a court order. If he does work, even within the legal trial limits, they use it to say he's fine. This leads to the core of the civil rights allegation, Section 504 of the Rehabilitation Act of 1973. Why is this being framed as a civil rights violation rather than just a standard bureaucratic error?
Section 504 prohibits any federal program from discriminating against someone solely because of their disability. The complaint argues that the SSA's administration of these benefits has become discriminatory because they've created a unique, high-stakes hurdle for him that non-disabled people don't face. By repeatedly demanding new applications, which then trigger new medical reviews, they are essentially using his medical condition as a way to keep him in a state of perpetual unentitlement. It's a denial of meaningful access to the program. The harm isn't just theoretical. The document lists homelessness, loss of healthcare, and extreme personal danger as the direct results of this 4-year delay.
The human cost there is staggering. When we talk about these POMs, the Program Operations Manual system, they seem like dry internal rules. But Robinson cites POMS GN 03101-230 and DI 10115.020 to show that the agency is ignoring its own rulebook. If the rules say don't relitigate and don't stop benefits without a medical improvement finding, and the agency does it anyway, it suggests something more than just a backlog or a slow office.
It's what the complaint calls ultra-vires agency action, acting outside of their legal authority. The SSA has the power to manage benefits, but it doesn't have the power to ignore a federal judgment or invent its own termination procedures that bypass the law. By requiring him to fill out Form SSA 521, which is a request for withdrawal of a claim, just to get paid on a different claim, they're allegedly setting a trap. If he signs it, he might inadvertently give up years of back pay. If he doesn't, they don't process the check. It's a procedural maze with no exit.
And the relief he's asking for is pretty comprehensive. He wants the back pay all the way from July 2004, the date his original DAC entitlement was established. He wants the withheld attorney fees released. But perhaps most importantly, he's asking for written confirmation that no more new applications will be required. He's essentially asking the SSA to stop the cycle and just acknowledge the status the court already gave him 5 years ago.
It's a demand for administrative finality. In the legal world, once a case is over, it's supposed to stay over. But for Landon Robinson, the end of his court case in 2021 was just the beginning of a different kind of struggle. This civil rights complaint is a high-stakes move to force the SSA's Office of Civil Rights and Equal Opportunity to look at the how and why of their internal processing. It asks, does the current system inherently discriminate by making it impossible for a disabled person to navigate the very rules meant to protect them?
It's a stark reminder that winning in court is often only half the battle. If the agency responsible for the payout doesn't move, the judgment is just a piece of paper. Robinson is now using the Rehabilitation Act to try and turn that paper into the support he was legally promised decades ago. It's an unfolding situation that challenges the idea of how final a federal judgment really is when a massive bureaucracy is on the other side. This case is a significant one to watch for anyone interested in how the SSA's internal rules intersect with the constitutional rights of individuals.
The focus now will be on how the SSA responds to the specific charge of using new applications as a weapon. If the agency's practice is found to be coercive, it could lead to changes in how they handle cases that have been remanded by federal courts across the country. Landon's situation highlights a gap between the judicial branch's decisions and the executive branch's implementation that can leave the most vulnerable citizens in a dangerous limbo.
It really highlights the tension between the letter of the law and the reality of administrative practice. For Landon Robinson, the wait continues, but the filing of this SSA 437BK marks a new phase where the agency's own civil rights obligations are finally under the microscope. If this topic is important to you, consider sharing this discussion to raise awareness about how these complex regulations impact lives every day.